do a report.
Right.
So we've got
Perfect. So Ms. Pugh, Mr. Jeffries has been appointed to represent you. He's just been given, he's trying to get caught up real quickly on all the information and the discovery in your case. I'm going to reset your case so that he can get all of that. Once he gets it, he'll be out there to go over it with you, and we'll see if we can get an announcement at the next court date.
Respectfully, Your Honor, I do not agree to comply with any of the appointed court agents, considering that their first duty is to the state.
I understand. We've had this conversation before.
And for the record, I'll be representing myself.
So if you want to represent yourself, there's some things. Ms. Pugh, stop talking over me. If you want to stop talking over me. If you want to represent yourself, then there is a process that we have to go through, and we'll do that today. If that's what you want to do, we'll get your case set for trial and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works, because here's what happens. When you're in a trial and you represent yourself, you're expected to know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury, and it's going to show, and it's just not going to be, it usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of things couple of options, and we'll go over those as well. Okay. So I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required. All right. So have you ever studied the law? Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you? Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Hold on a second. Let me pull you up here. We'll go over that again as well. The date of that allegations from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years as a minimum punishment up to 10 years in prison, anywhere in between. Do you understand? And did you answer out loud just for the record?
Do I understand? No, I don't understand.
What do you not understand about that?
I don't understand.
So here's the thing. If you want to represent yourself by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney for you. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States. This is the law that applies to your case. So what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it.
I don't understand because I have no idea anything wrong.
That's what a jury's for, right? And so if you say you're not guilty, then you go in front of a jury and they determine, after they listen to the evidence, if you're guilty or not. That doesn't have anything to do with if they find you guilty, you understanding that they could send you to prison for between 2 years and up to 10 years. Do you understand that part? What are you, yes or no? No, you don't understand that. So, Ms. Pugh, it's my understanding, I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case. I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff. Go back with the bailiff. Welcome to the criminal appointment list.
Yeah, fun, Judge.
This was not meant to be any kind of punishment, I promise. So Mr. Jeffries, just, get ready like you would. Probably it's going to go straight onto a jury.
Right, I would
And
assume.
we'll just get it figured out that way. All right.
In a Texas criminal courtroom, proceedings begin with the case of State versus Pugh. The presiding judge addresses the defendant, Ms. Pugh, informing her that Mr. Jeff has just been appointed as her legal counsel. Since he has only recently received the case materials, the court will reset the case to allow him time to review the discovery, meet with Ms. Pugh, and prepare for the next hearing. At this point, tension begins to rise as Ms. Pugh attempts to speak over the judge. The court firmly instructs her to stop interrupting and listen carefully. The judge then turns to address her apparent dissatisfaction with legal representation. Tone, judicial explanation, and warning. The judge reminds Ms. Pugh that while she does have the constitutional right to represent herself, such a decision is highly inadvisable. The court explains that lawyers undergo years of training to understand the rules of evidence, trial procedure, and courtroom decorum, skills necessary to properly defend a case before a jury. Representing oneself, the judge warns, comes with serious disadvantages. If you don't know these rules, it's going to show, and it usually does not work out in your favor. Nevertheless, the court agrees to go through the formal process required when a defendant insists on self-representation. The judge begins a competency inquiry, a standard legal procedure to determine whether the defendant fully understands the consequences of waiving their right to counsel. Transition. Competency inquiry begins. Cautious judicial tone. The judge proceeds with a series of structured questions. Has Ms. Pugh ever studied law? Has she ever represented herself in a criminal matter before? Does she understand the charges against her? Does she understand the range of punishment if convicted? As the inquiry unfolds, it becomes apparent that Ms. Pugh struggles to grasp the process. The judge carefully explains that her alleged offense, dating from June 22, 2021, carries a potential sentence of 2 to 10 years in prison, depending on the jury's verdict. When asked if she understands this range of punishment, Ms. Pugh responds ambiguously, stating she does not understand, and later adding confusing statements about the jury's role. The judge attempts to clarify, the jury determines whether you are guilty or not. But if they do find you guilty, they can sentence you anywhere between 2 and 10 years. Do you understand that part? Ms. Pugh still does not give a clear acknowledgement, leading the judge to conclude that she does not fully comprehend the legal proceedings or potential consequences. Tone, judicial determination, firm but controlled. At this point, the judge makes a formal ruling on the record. Ms. Pugh, it's my understanding that you do not understand the law or the process. Therefore, I will not allow you to represent yourself. The judge explains that self-representation is not simply a matter of preference or dissatisfaction with an attorney. It requires a demonstrated understanding of legal procedure. Since Ms. Pugh cannot meet that standard, Mr. Jeff will remain appointed as her defense counsel. The court notes that this decision is for the defendant's own protection and to ensure that the case proceeds within the bounds of due process. The judge also informs counsel that the case will likely be set for jury trial, emphasizing preparation and compliance with procedural standards. Closing scene, tone shifts to reflective and procedural. As the defendant is escorted out of the courtroom, the judge reassures counsel. This was not meant as any kind of punishment. Welcome to the criminal appointment list. The session ends with instructions to proceed toward trial, now under the continued guidance of appointed counsel. The tone of the court, though firm, carries a sense of procedural fairness and protection of the defendant's rights, even against her own misjudgment. The hearing underscores a central tenet of the American judicial process. The right to self-representation is not absolute. It must be balanced with the court's duty to ensure that a defendant is competent, informed, and capable of understanding the consequences of their legal decisions. Summary closing note, neutral, documentary voice. In the end, State v. Pugh highlights a fundamental courtroom dynamic, the intersection of individual autonomy and judicial responsibility. The judge's careful inquiry, though strict, served as a safeguard against self-inflicted legal harm, ensuring that justice proceeded with both order and fairness.